This lecture will exclusively deal with the Constitution of India and the very form of democracy that India adopted and the very role of judiciary in upholding the constitutional guarantees and the protection of individual liberties and fundamental rights. So, in connection to that, we would like to first discuss the very importance of judiciary in a vibrant democracy, that is the democracy of India. So, in that connection, we found that the judiciary is the guardian of the Constitution and protector of fundamental rights and individual liberty. And the very role of judiciary is infusing life into directive principles of state policies as it is portrayed under Part 4 of the Constitution of India. Besides that, the primary fundamental role of judiciary to upholds justice, equality, and rule of law. So, the judiciary holds a central position in the democratic framework of India, acting as both the guardian of the Constitution and the protector of individual liberties. Its role is not merely to adjudicate disputes but to uphold the value of justice, equality, and rule of law that are enshrined in the Constitution of India. The judiciary serves as a hallmark against the arbitrary exercise of power by the executive. In regards to that, the judiciary serves to check the very arbitrary exercise of power by the executive and the legislature, ensuring that all actions conform to constitutional mandates under the Constitution of India. So, as India, a country of diverse and complex with multiple religions, language, and social status, the judiciary plays a crucial role in maintaining social balance and promoting inclusivity. It revolves and resolves the conflicts, checks governmental exercise of powers, and interprets laws in a manner that we found that it upholds the constitutional morality. Landmark judgments by the judiciary have expanded the very ambit and scope of fundamental rights, and it also infused life into the directive principles of state policy. For example, through public interest litigations, the courts have addressed systematic issues such as bonded labor, environmental degradation, and gender justice, thus serving as a tool for social transformation. Moreover, the very independence of judiciary ensures that it remains insulated from political and economic pressures. This independence is critical for upholding the faith of the people in justice delivery system. When citizens view the judiciary as a neutral and unbiased arbiter, It strengthens the very rule of law and democratic governance. In essence, the judiciary is not just a dispute resolution mechanism, but the guardian of constitutional ethos and a catalyst for social justice. It ensures that justice is not just done, but seems to be done, thereby reinforcing the ideals of democracy in Indian context. So, in context to independence of judiciary, will deal in another separate lecture. Now we will see the very independence as we found under the constitutional framework, and in particularly the very provisions of Articles 124 to 147 dealing with the Supreme Court of India, then Articles 214 to 231 relating to the jurisdictions of high courts of the states, then in particular the applying the provisions of Article 13, Article 32, Article 226, Article 141 and 42 of the Constitution of India. And in that connection, we would like to discuss the most important landmark judgment delivered by Supreme Court in Keswananda Bharati versus State of Kerala in 1973. Why the Supreme Court? Why pronouncing and innovating the very doctrine, that is the doctrine of basic structure. So the Indian Constitution provides for an integrated and independent judicial system. The architects of the Constitution recognize that the judiciary must be insulated from legislative and executive interference to discharge its functions effectively. As such, the Constitution incorporates elaborate provisions for the very structure, powers, and independence of the judiciary. So, in particularly in Part 5, which contains Articles 124 to 147, deals with the Supreme Court, the apex judicial authority, while Part 6, dealing with Articles 214 to 231, governs the high courts in India. These articles define the jurisdiction, powers, and functioning of the courts at the national and state levels, ensuring a comprehensive legal framework. The power of judicial review, as we found answered under Article 32, empowers court to strike down laws that are inconsistent with the Constitution, as in particularly under the very provisions of Article 13 of the Constitution. The binding nature of Supreme Court judgments under Article 141 ensures legal uniformity across the country, while Article 142 empowers the Supreme Court to pass orders necessary for complete justice in any case before it. These provisions, as with doctrine of separation of powers, form the constitutional backbone of Indian judiciary. Very important role played by the judiciary by making interpretation of these provisions expansively to uphold the very spirit of the Constitution, the evolution of the basic structure doctrine in the important landmark judgment, case one on the Bharati versus State of Kerala, could be cited As a prime example, this doctrine restricts Parliament from altering the core features of the Constitution, thereby cementing the judiciary's role as its ultimate guardian. So, now we would like to discuss the very hierarchical structure of Indian judiciary, in particularly at the apex of the Indian judiciary. It is the Supreme Court, and below Supreme Court all the high courts of different states in India. Then below the high courts, those subordinate courts. And we would like to discuss here their very establishment and jurisdiction. Then, in particular, the Indian judiciary follows a unitary and integrated hierarchical structure that functions uniformly across the country, ensuring legal coherence and accessibility. The structure was influenced under the British legal system and is designed to accommodate the needs of a vast and diverse population. The hierarchy comprises the Supreme Court at the apex, followed by high courts at state level and various subordinate courts below them. So, the very Supreme Court of India, as for the provisions of the Constitution, is established under Article 124, and it is the final court of appeal and constitutional interpretation. It consists of the Chief Justice of India and up to 33 other judges, and the very court has multiple jurisdictions, such as original jurisdictions, as under Article 131 of the Constitution. It allows the Supreme Court to resolve disputes between the center and states. And appellate jurisdiction as provided under Articles 132 to 136 provide for appeals in civil, criminal, and constitutional matters. Besides that, advisory jurisdiction, as provided under Article 143, which enables the President to seek legal advice from the court. As recently in the month of July, the President of India made reference to the Supreme Court regarding the very judgment delivered by a bench of the Supreme Court regarding the very time limit as pronounced by the single judge bench of the Supreme Court, that the time limit to give assent to any bill is only 3 months. So, regarding that, the present President of India, Mrs. Draupadi Murmu, made a reference to the Supreme Court under Article 143 of the Constitution, which contains advisory jurisdiction. Further, Article 32 provides writ jurisdiction to the Supreme Court to enforce fundamental rights which are guaranteed under Part 3 of the Constitution of India from Article 13 and 14 up to Article 35 of the Constitution. Besides that, Article 136 of the Indian Constitution empowers the court to grant special leave against any judgment of any court in India. And here we want to make clear that almost regarding all the jurisdictions of Supreme Court, we have already made lectures, and that one can found in our channel under the playlist Supreme Court jurisdictions. The Supreme Court is also the guardian of the Constitution and exercises the power of judicial review to strike down unconstitutional laws. And as such, regarding high courts of different state, each state or a group of states or union territories has a high courts as the highest judicial body within the jurisdiction that provided under Article 214 to Article 231, which governs the very structure and powers of the High Courts. So, the High Courts in India of states, they have original jurisdiction in civil and criminal cases under certain circumstances. They have also appellate jurisdiction, the appeals from lower courts. Besides that, high courts they enjoy writ jurisdiction under Article 226 of the Constitution, and that writ jurisdiction is wider than the Supreme Court's jurisdiction under Article 32, as it covers not just fundamental rights but also all other constitutional and legal rights. Besides that, high courts also supervise and control subordinate courts as provided under Article 227 of the Constitution, ensuring uniform judicial practice within their jurisdiction. And besides that, there are number of subordinate courts. These include districts and sessions courts, civil courts, family courts, and magistrates courts governed by the Code of Civil Procedure 1908, the Code of Criminal Procedure 1973, and respective state laws. These courts form the very foundation of Indian judiciary. At the district level, the district judge head of the civil judiciary in a district, and a sessions judge who handles criminal cases at the district level, and judicial magistrates they try criminal cases of lesser gravity. These courts plays a vital role in delivering justice at the grassroots for a majority of citizens. Subordinate courts are the primary point of interaction with judiciary. And now we would like to discuss the very appointment, tenure, and retirement. And in connection to that, we would like to discuss the first and second and third judges appointment cases, then National Judicial Appointment Commission, and versus the collegium system. So, for a transparent, merit-based and independent process of judicial appointments is crucial to maintaining the integrity and credibility of the judiciary. So, appointment of judges to Supreme Court and High Courts are made by the President of India. However, in fact, the process is governed by the collegium system evolved through three landmark judgments. So, the first one is the first judge's case, which is otherwise known as S.P. Gupta versus Union of India in 1981. Already we have delivered a lecture on S.P. Gupta versus Union of India in 1981, and that one can found under the playlist landmark judgments. And in particularly in this important landmark judgment, Supreme Court held that the executive had primacy in appointments. And in the second Judge's appointment case in 1993, it established that the Chief Justice of India and senior judges have primacy. And in the third Judge's appointment case in 1998, which clarified the composition and functioning of the collegium system. The collegium comprises the Chief Justice of India and four senior most judges of the Supreme Court. For Supreme Court appointments and the Chief Justice of India with two senior most judges for High Court appointments. Even though critics argue the system lacks transparency and is susceptible to favoritism, the National Judicial Appointments Commission Act 2014 aimed at reforming this was struck down by the Supreme Court in 2015 in the very important landmark judgment, and that was Supreme Court Advocates on Record Association versus Union of India, where it upheld the very National Judicial Appointments Commission Act of 2014 as unconstitutional. And now we'll discuss regarding the very tenure and retirement in relation to Supreme Court judges as they retire at the age of 65 and High Court judges retires at age 62. This tenure ensured that judges have a fixed term, offering them a reasonable period to contribute while minimizing the risk of arbitrary removal. And now we'll go to regarding removal of judges as provided under Article 124 Clause 4 and Article 217 Clause 1 Subclause B of the Constitution on the very ground of proved misbehavior or incapacity. So Article 124 Clause 4 of the Constitution provides the very procedure for the removal of Supreme Court judges. And Article 217 Clause 1 Subclause B applies to High Court judges. A judge can only be removed on the ground of proved misbehavior and incapacity through a rigorous impeachment process. So, at present, in the very month of July, in Parliament, a motion was moved by more than 100 members of the House of People or Lok Sabha and more than 50 members of the Council of State or Rajya Sabha for impeachment of the presiding judge of Allahabad High Court, who was formerly a judge of Delhi High Court, Justice Jaswant Verma, and the motion is already in the inquiry committee to be set up by the Speaker of Lok Sabha and the Chairman of the Rajya Sabha or the Council of States. So, in this part, this is considered as part one relating to the very constitution, democracy, and judiciary. Almost we have discussed. But exactly the very provision of removal that at present moved against Justice Jaswant Burma. The constitutional requirement is that the motion for impeachment of a judge must be supported by 100 Lok Sabha and 50 Rajya Sabha members, and it must be inquired by a committee comprising a Supreme Court judge, Chief Justice of a High Court, a Chief Justice of India, and a distinguished jurist or expert in constitutional law who could be appointed by the Speaker or Chairman of Rajya Sabha, and it needs the approval by a two-thirds majority in both houses of Parliament, and the very process has rarely been invoked. At present, the very move is to impeach the judge of Allahabad High Court, who was formerly a judge in Delhi High Court, Justice Jaswant Verma. As notably, we found Justice V. Ramaswamy in 1993 faced impeachment proceedings which failed in the Lok Sabha due to political consideration. While the procedure ensures judicial independence, critics argue that the near impossibility of removing an errant judge or judges make sometimes foster impunity. As a result, there have been demands for establishing a more new and developed mechanism for judicial accountability. So, all this that we have discussed in relation to this lecture, the very importance of judiciary in a democracy, and the very role of the Constitution of India in upholding the individual's liberties and fundamental rights. And as judiciary is the guardian of the Constitution, and ultimately it upholds justice, equality, and rule of law. And in that context, also we have discussed the constitutional framework provided regarding establishment and the very jurisdictions provided to the Supreme Court, High Courts, and subordinate courts in India, and their appointment, tenure, retirement, and also removal of judges. And in our next upcoming lecture, that would be part 2 relating to constitution, democracy, and judiciary. We will discuss the very powers and functions of the Supreme Court and High Courts.